Jim O'Callaghan.
I suppose sexual offences in Ireland are unique when you look at the criminal code because they're targeted nearly exclusively against one group in Irish society, and that's women. So I know that there have been and there are sexual offences that are perpetrated against men, but predominantly these are offences that are perpetrated against women. And we need to recognise that when they're being perpetrated, they're offences that are combined with physical violence as well as sexual violence against that victim. I think that the Gardaí in Ireland are getting much, much better with how they investigate sexual offences. I think that's recognised when you talk to people who have been victims of sexual offences, that in many instances they're now saying that the Gardaí perform particularly well in the investigation of them. We need to figure out in this House what we can do to facilitate and to protect women who, as I say, are predominantly offended against when it comes to these offences. I'm pleased to say, when you look back at some of the legislation that's been introduced over recent years, that they do provide greater protections to women who are victims of sexual offences. I also think more broadly, when you look at 2017, we introduced legislation recognising really for the first time the importance and role of victims of crime in our criminal justice system. For too long, the whole criminal justice system has been very focused upon the issue of the guilt or innocence of the accused. I think it's very important now that we recognise that victims have an important place to play in the whole process of the criminal justice system. I want to commend Minister Brown for the work he has done on this piece of legislation and bringing it before the House today. Obviously, I commend Minister McEntee as well. It is an extremely important piece of legislation. Members of the House have already spoken about the provisions within it. I don't intend to repeat what's been said more eloquently than I have by other members of the House, but I think there is universal support here for this legislation, and that's indicative in itself of how there's a recognition in this House that more needs to be done to protect victims of sexual offences. What I wanted to take my time doing, however, Lascan Corda, is I'd like to refer Minister McEntee and indeed Minister Brown to an article that was published about 10 days ago in the Irish Judicial Studies Journal, and it's entitled "Towards a Presumption of Victimhood: Possibilities for Rebalancing the Criminal Process." This was an article that was written by Peter Charlton and by Orla Cross. They set out in it how they believe that the criminal trial and the criminal justice process again needs to be rebalanced more in favour of the victim. They're not suggesting in any material way that the rights of the accused should be diminished or that there shouldn't be recognition that the presumption of innocence should apply when it comes to somebody who's charged with serious offences. However, the article does put forward a number of proposals in respect of rebalancing the trial process. And I think one thing that all of us in this House are aware of is that when you speak to women, and it is predominantly women, who've been through the process of a criminal trial where an accused is being prosecuted for a sexual offence against them, they find the criminal trial process very intimidating and very demanding. I think we have an obligation in this House to try to change that so as that it's not as demanding or as intimidating. And in the article, a number of suggestions were put forward by the authors as to how that could be done. And one of the suggestions they've put forward is that providing information to somebody who's the victim of an offence, whether it's a sexual offence or not, is not enough in itself. I know in this House in recent times we've introduced measures that will give more information to a complainant in any trial and obviously to the victim in a sexual offence trial. But it's pointed out that simply providing information to the victim isn't enough in itself. The second point they make is that on numerous occasions we've spoken in this House and recommendations have been put forward that the victim in the criminal trial process should have separate legal representation. Now that can happen under legislation that exists at present in circumstances where the victim is being cross-examined and it's believed that the prosecution counsel isn't providing sufficient protection. But what's suggested in the article is that there should be a closer encounter between the victim and prosecuting counsel. We know that in a criminal trial that the prosecuting counsel is prosecuting on behalf of the DPP, namely he or she is representing the interests of the state. it is true to say that they are not employed or hired on behalf of the victim. But the reality is that the prosecuting counsel and the DPP is representing the interests of the victim who has made a complaint which the DPP believes is sufficient to launch a prosecution. So there needs to be closer encounters between prosecution counsel and the victim in a criminal trial process. A third point they mention is that maybe it's necessary for counsel and solicitors to engage in training by professional bodies and perhaps state parties engaging counsel and solicitors. And that's something that we have spoken about before, but we haven't really done that much about it. And it's notable that in England and Wales there is a jurisdiction that exists to the Advocates Gateway, which provides a toolkit on questioning vulnerable witnesses and up-to-date resources. So that's something that I think we should also look at. Another point, I suppose, that is sometimes referred to by people who have gone through the trial process is that they say that they found the cross-examination process very intimidating and very demanding and very challenging. Obviously, cross-examination plays a very important role in trying to establish the truth. Nobody is suggesting that the right to cross-examination should be taken away from any accused person. But it certainly must be the case that the right of cross-examination can be curtailed or limited in time. We see that happening already in civil trials, and it hasn't resulted in miscarriages of justice or inaccurate results. Similarly, when it comes to criminal trials, I think we need to look again to ensure that cross-examination is not permitted to go on endlessly for the sake of simply trying to undermine the witness and to try to make the witness exhausted during the process. And another point that is made is most times an accused doesn't give evidence. I'm not suggesting that an accused should be required to give evidence. But in the article they refer to how the self-serving statements by accused persons who do not give evidence are read out, the statement of the accused in the Garda station. We need to look at that as well. Thanks very much. That's Ken Corley. I see my time is up.